Hello and welcome to the consultation. My name is Christina Jimenez. And you are, sir?
I am Josh Floyd.
And we are both attorneys in the state of Texas. We have a few different law firms, a couple in the Metroplex and one over in West Texas. And every Friday we get on Facebook Live and we talk about complex legal issues. Make sure that you follow us on all social media platforms. We have TikTok, LinkedIn, YouTube. We have podcasts on Spotify and on Apple. We have Instagram, Facebook. We have everything. If you have heard of it, we're probably on it. And so on Fridays, we come together, we talk about different complex legal issues, go through some fact patterns. We tell everyone at the beginning, middle, and end of this thing, please do not accept this as legal advice. And the reason is because we don't know your situation, right? And everybody's situation is always going to be different. And one little nuance in a fact pattern could potentially change our perspective on the entire case. And so the idea and the hope is that we provide some general information for you guys that will give you some insight or help you along the way. But if you find yourself in a legal situation, make sure that you hire your own attorney and you listen to that attorney after you tell them your story. And I'm not sure, but hopeful that that attorney will put you down the right path. So with that being said, Floyd, do you want to read the question? You're muted, Floyd. I'm going to need you to get it together, sir. It's Friday. You've had all week to get it together.
It's been a rough one.
Why have we been saying that like every Friday? Like it's been rough.
Been a rough one like every week.
I know.
That's been crazy. Okay.
Go.
All right, here we go. Can my current wife be held responsible for any possible mortgage debt incurred after the divorce if I am deceased? I gave up responsibility for a house my ex and I purchased during our marriage. Included in the divorce was a special warranty deed where I gave up the house and transferred all debt to my ex. My name is still on the original deed as I never had it removed. Can I be held responsible in any way for future debt concerning the house that my ex may bring? I did not have a deed of trust to secure assumption in the divorce decree. Womp womp.
So I think it's funny that he knows about a deed of trust, didn't incorporate it. So what I'm presuming is going on is he's probably gone and he's consulted with another attorney, and now he's freaking out because he didn't like the answer that was given to him by the other attorney.
Sounds like he may not like our answer either.
I don't think that he will, little friend.
Have we done this question before?
I am sure in some way, shape, or form we have discussed it, but I don't know that we've done a deep dive into deeds and muniments of title and notes and how all of this crap kind of plays out. And so, first things first, if you are going through divorce and if you own any property, and especially if you have property that is jointly, there's a note where you both are jointly liable, please hire an attorney. Like just hire an attorney. I don't care if it's just one little baby house and there's not a whole lot of equity, hire an attorney, because I see this type of situation all the freaking time. And it's a disaster. And there's very little that we can do to fix it once this happens. So, Floyd, are you trying to talk?
I'm not trying to talk, but I can.
No, I'm okay. I like to hear myself talk.
I know.
So, do you want to talk about, I don't know, where do we start? Like creditors and how that whole thing plays out?
That's a good spot. We can start there.
Go. Do it.
Do we want to be specific to mortgage? I guess we just, debts in general, right? But specifically mortgages?
I mean, that's what the question's about, is about a home with a mortgage.
Well, so essentially they're handled the same, right? If your name is on any debt, including but not limited to a mortgage, you have signed a contract with that creditor allowing them to hold you responsible for that debt, right? And just because you get divorced and the decree says now ex-wife is responsible, that does not then force the creditor to solely look at ex-wife, right? The creditor still can go by the binding contract that you signed saying you can also hold me responsible. So if there's joint debt, regardless of what the decree says, you're both responsible as it relates to the creditor's perspective and their ability to come after you and things like that. Are there other remedies that you may be able to get through the decree? Probably, right? But they're going to be difficult, and it's easier just to do it right the first time and avoid all this.
How is it that we go in and I guess get rid of that creditor?
So a joint creditor, is that what you're asking about?
Yeah, so in this particular case, if husband's name is on the mortgage and it has been awarded to wife in the final decree of divorce, what is it that we typically do to make sure that eventually husband's name gets off that note?
So what we would do is put a provision in the order that requires ex-wife to refinance the home, removing husband's name from the note and removing him from any financial liabilities associated with the home. Give her X number of days, 90 days, 180 days, a year, whatever, to accomplish that. If she does not get it done within that time period, then the house gets sold.
So what I would say that I've learned like over the years is if you are going to negotiate that particular provision, if you're an attorney and you're going to negotiate it, or if you're a potential client and you are in that particular situation, make sure that you're going to actually qualify for the refi. Because I've had that happen on several occasions where the clients are like, yeah, absolutely, I'll be able to refinance, no big deal. And then a couple months later, it's like, no crap, I can't. I know that with COVID, there were several people who took advantage of the forbearance stuff, right? And so then what happened was when we're going through this divorce system, we're still dealing with it. When we're going through these divorces, because they did the forbearance, they're not eligible for a refi. And I think most mortgage companies state that you cannot have missed a payment for the preceding 6 months if you're going to go in and refi. And that's something that's going to be specific to your mortgage company. And so what I always encourage all of our clients to do is call the banks and call the mortgage companies and figure out, am I going to be able to do this or not? Because what you don't want to do is agree to something and then set yourself up for failure, and then you're screwed.
Yeah, another thing you have to look at is how much equity is in the home, right? Because generally on a refi, you can only refi at 80% of the value, right? And so if there's not a lot of room there and you can only get 80%, it may not be enough to pay that note plus the additional closing costs and stuff you have with the refi. So even if you are able to credit score wise, right, you may not be able to just equity wise.
Well, and then the other thing that you have to think about is your debt to income ratio too. That's another thing that people are always, forgetting about is, and again, that goes back to the qualification, right? You go to a bank and you say, here's my debt, here's my income, here's my credit score, here's my consistent payments that I've made on the home. Am I going to be able to, and here's the equity in our home, am I going to be able to refi? And if not, then you may not want to do that. You may just want to agree to sell it and be done with it. And so one of the things, I guess, what do you think about the length of time to allow somebody to refi or sell?
I think it depends on the case, right? So I usually try to stick around 90 or 120 days. But if I have a single mother that's been unemployed for a while or whatever, most of marriage, I'll generally give her more time. that kind of thing. Someone that's going to be difficult, we can give them more time, but generally try to stay around the 90 to 120 days.
Yeah, I mean, I say like up to 180 is pretty standard. But I mean, I've had cases where we negotiated for like up to 3 years, up to 5 years, up until the youngest child turned 18 years of age, right? And obviously, depending on what side you're on, that's going to determine if you're going to agree to that, right? So what I would say is if you are the party that is not going to be able to keep the home, or you're not going to be living there and basically have it awarded to you, then you probably want to limit that, right? Because in those situations where that has been negotiated, if my client's the one that's agreeing to it, I'm basically telling them, listen, you're likely not going to be able to buy a home for the next 5 years, because your debt to income ratio is going to be way out of whack. And you're probably not going to be able to qualify for another home. And obviously that depends on the mortgage and how much is owed and all that other crap. So that's just something to be mindful of as you're negotiating the length of time. But I've had lots of people, and most of the time it's dads, that will say, it's okay, I want to make sure that my kids have a home until, they're 18 years of age. And so they'll just agree to it. But the other thing is, if they don't pay, if she doesn't make the timely payments, Mr. Floyd.
So we typically require the sell, right? And so one of the things I was going to mention, which I guess, I don't know if this is what you were intending for me to mention, but you're going to take credit for it anyway, I'm sure.
Likely.
Yeah. Is you've got to be careful when you're giving them time, when you're talking about the sell provision, as to how the equity is going to be divided. Right? Is the equity at the time of mediation, the time of divorce? Who's going to be making the mortgage payment? Are they going to receive reimbursement for that when it's divided? That's what you wanted, right?
No, but go ahead. I mean, this is an excellent point as well.
Yeah. So I'm surprised you didn't take credit for it since you thought it was an excellent point.
Actually, yes, that's what I was talking about.
I need everybody on Facebook to mark the calendar that I did actually get credit for something I did. But yeah.
Sir.
So yeah, you got to be careful when you're on the side that, well, either side really. And sometimes if you're the person that's not getting the home, you give a little longer, and you kind of use that to your advantage and maybe get some more out of it. If they're not going to be able to refinance, you can kind of bank on them not refinancing and the ignorance of the other attorney to deal with that provision, and you could end up better off. But make sure that is addressed when you're dealing with the sale, or giving them time, because the equity is going to be different, and somebody's going to be spending money on taxes, insurance, and mortgage and stuff like that. So
I guess, number one, I think you did a really crappy job explaining all of that. And so let's kind of back it up just a little bit and let's talk about it. So if you are keeping the house, so in this particular case, it was the wife that kept the house and the husband's the one who did not do what he was supposed to do. When would you want to calculate the equity of the home?
If I represent, who do I represent?
Wife.
So if I represent wife and I'm getting 6 months to refi?
Sure.
Okay. I would want to calculate it at the date of mediation.
Okay. And why would you want to do that?
Because the equity is going to increase from that point forward. And so I don't want to give him any more money than I have to.
Okay. And so what if we're on husband's side and we're saying, wife, we'll give you 2 years to be in the home because we want the kids to be okay. Then what would we typically try to bargain for?
He would say that if you can't refinance it, it's sold and divided 50-50 at the time
of divorce. Now,
of sale.
Excuse me, of sale. Thank you. We haven't had that issue come up with regard to the enforceability of it because, I think there's an argument that could be potentially made that it's her separate property, right? Any equity that she's acquired after divorce I think that's an argument that can be made, but she would have contracted for it. And so I think that most judges would say, you said you were going to do this, so this is what you have to do. But it is definitely something to kind of keep in mind. I will say, like, typically when I'm doing this, I try to do it like a set amount at the date of mediation, just because I have had people who've come in to hire us from other firms, and cleaning up the amount that somebody actually gets is a freaking nightmare. And you just get tied up in litigation, and the money's just sitting in somebody's trust account, and the parties are not getting what they need.
Yeah, I've seen them as complex as, they get a certain percentage of the equity, but one party gets reimbursement for interest payments made on the mortgage and 50% of the taxes and insurance. And yeah, it's a nightmare calculating all of that.
Right. So you can do it. And that's kind of the, I guess, brilliant thing about mediation is that you can bargain for anything, right? We can set it up any way that you can think of. And I mean, judges can award it that way as well, but typically they won't do that. Like in my experience, if we have a home and one party wants the house and the other party wants the house, judges are going to make you sell the house. I mean, that's 9 times out of 10, that's what they're going to do. Or they'll give a party a very short window, like 90 days to refinance, or then they're going to make you sell it. Because they don't want to be, again, causing more litigation and more cases on their docket and just more crap. What else when it comes to removing the creditor from, or I guess one of the spouses from the note or the mortgage?
So we do the deed of trust secure assumption, which is what this guy had brought up. And basically what that does is the party that's taking the residence would sign the deed of trust and secure assumption, basically saying, I am being, in this case, wife is responsible for the mortgage. And if she fails to pay the mortgage payment or insurance payment, whatever is required under the mortgage note, then the husband would have the ability to come in, make those payments, and foreclose on the property, basically.
Yeah, well, he has to pay, and then he has to demand reimbursement and give her a certain amount of time. And then if she does not, then at that point he can say, hey, I've, have $2,000 in this that I had to pay. Now I want this house sold so I can recover my money. Typically when the deeds of trust are drafted, they say that you're also awarded any attorney's fees if you have to come in and take that home. And then basically the proceeds would be split pursuant to the decree. And so if wife was supposed to keep 100% of the equity in the home, and husband wasn't going to get anything, then husband would be paid back what he had paid the mortgage company, and then any attorney's fees he's out, and then wife keeps the rest. So
True that.
And the purpose of a deed of trust to secure assumption is so that even though this mortgage is on your credit history and you're going to be liable for it, it is to prevent or to give you the ability to prevent it from negatively impacting your credit score, right? And so it gives you the right to make those payments so that you don't have a missed mortgage payment and it doesn't screw up your credit, right? Now, does it suck that you have to make a mortgage payment for a house that you're not living in? Absolutely. Which is why we typically like short windows if we're representing the spouse that's not getting the house, because I don't want him to have to mess with that, right? But it is a remedy, and it does give you some leeway. What about if, in this case, wife is paying the house, paying the mortgage, but she's late, like every month, but she pays it, and husband doesn't pay it pursuant to the deed of trust to secure assumption?
Well, in this case, this guy would be screwed. We can put provisions in decrees that say, if the insurance lapses, if the payments aren't made for 3 consecutive months on time or whatever, you can put any provisions you want in there to force the sale of it. And so if I'm representing, in this case, the husband, I would put clauses in there like that to make sure that although it may not be late enough to satisfy the deed of trust and secure assumption, that if there's 3 months of payments that are late, he still has a remedy. He can go in and force the sale, something along those lines.
One, I think that you could include those remedies you would want to include those in the deed of trust to secure assumption, right? Because that's what actually would give him the right to go in and do what it is that we need him to do, which is sell it so that it's out of his name.
Well, maybe because you could just have a provision in the decree that says that if she does ABC, then she has to put the house up for sale, right? And so if she does ABC, then you can file a motion with the court to compel the sale of the house without having to go into the deed of trust.
Or you could do both.
Or you could do both.
And I think like the best thing would be to do the deed of trust.
Maybe if your client has the money to pay the mortgage and stuff to catch it up and the time to wait on that waiting period and request reimbursement and all that under the deed of trust.
Oh, what I'm saying is in the deed of trust, you would say if you're more than 5 days late, that triggers the deed of trust to secure assumption.
So I just want to point out that fool is rude.
And I'm right. Go ahead. And you can just say, and I am peaceful.
It's not a very professional, polite way to handle the situation.
Right. Thank you.
And I'm going to speak to HR.
So I'm sure they're already listening. So I'm used to it. I'm used to being called into the office. So I would say do both, but definitely, most certainly put it at least in the decree so that you have some sort of a remedy.
Well, then what if, so you were talking about earlier how you like to specify a number, right, that the spouse is going to get. How would you protect that?
What do you mean?
So if husband, in this case, is going to get $50,000 at the time of the sale, he signs a special warranty deed that deeds her the property. Okay. So how would you make sure that when it was sold, he got his $50,000?
That would be in the deed of trust to secure in the special warranty deed. God dog it, Floyd, don't confuse me. My daughter just walked in and she threw me off, and it is a deed of trust to Ulti. Deed of trust to secure Ulti of partition. Boom, got it.
And a real estate lien note.
And a real estate lien note as well. Yes, I knew that.
And a special warranty deed with encumbrance for partition.
Yes, Floyd.
For those
Didn't I teach you this?
You did.
I taught you this. Yeah. Now you're trying to act like you just freaking know everything.
I think it was pretty clear that you didn't know the answer.
So, right. Okay. So I guess let's talk about that stuff briefly. Gosh, this is like way more complicated. Why do we always complicate things?
Property law is very, very complex.
That's horrible. Okay. So special warranty deeds. That is what you sign in order to transfer the house to the other person's name, right? So in this particular case, husband executed a special warranty deed to say, all right, my wife and I, the original deed was in both of our names, and now I'm going to transfer my interest solely to my wife. And so that's what gives wife the ownership, the ability to refinance, to be able to sell it, to do whatever the heck she wants to do with it. Now, if husband was supposed to get like $50,000 worth of equity from the home, what you would do is you would do a special warranty deed with encumbrance for Ulti of partition. It's something like that. I think I screwed up the name, but I think
you got it.
I got it. Okay. And so in the special warranty deed, it would say, hey, I'm conveying my interest to this home, but I'm still owed $50,000. And so anybody who wants to come in and purchase it, or if they're going to do a refi, everybody's going to be on notice that he's entitled to the $50K. And then wife would also execute what we call a real estate lien note, basically like a, I guess, contract, for lack of a better term, saying, hey, I understand and I agree that I owe him this $50,000. Most importantly, all of these documents that we're talking about, they need to be filed with the county clerk's office of the county where the property is located. Because that's how you put the rest of the world on notice that you have a property interest in that particular piece of real estate. And then what's the other thing that we say? Why are you making a face?
Well, I was about to start a sentence and you asked me a question, and I was thinking about the other thing because that's a very vague statement. I have no idea what you're talking about.
Deed of trust to secure, and then the deed of trust to secure royalty of partition. Yeah. Why don't you explain that, Mr. Know-it-all?
So it's essentially the same thing as a deed of trust to secure assumption, except rather than it securing the mortgage, it's securing the ulti lien, which is the $50,000 in this case.
Yeah. So the other thing is in the final decree, and I see this a lot, there has to be what we call order language. The order language needs to order each party to show up at a specific place at a specific time to sign all of these documents. Because if they refuse to sign these documents, then here we go again. We have to file more motions. We have to set more hearings. We have to run up costs on everybody just to make somebody sign a document that they should sign pursuant to the order.
Unless, what can we do to the decree to ensure they're protected if they don't sign?
So yes, but that's not for everything. You can't trick me. You cannot trick me. So the one thing that we always put in our final decrees is this language that says, this decree shall serve as a muniment of title. I think that's it. That's the sentence. Yeah.
Affirmative.
And then what you can do. So let's say hypothetically speaking that it's just a deed, right? So we just need to make sure that the world knows that this house was conveyed to wife and husband's being a jerk and he doesn't want to sign the deed. Instead of spending all that money to get a deed signed and filing a motion compelled to make him come in and sign it and all that other crap, you can just file the decree with the county clerk's office. It's not the best thing. I prefer to not do that if I can avoid it. It's going to cost you more money to file it with the clerk, but that's sufficient. Now, where it gets tricky though, Floyd, is why I say it won't work for everything, is the deed of trust to secure assumption, like the real estate lien note, like all of that crap. If wife is refusing to sign it and you don't have that order language, then you're going to have to file more crap.
Yeah. So if you had the deed of trust to secure assumption, you're right. So
yeah, I think that we have this all on recording.
Do you know what muniment means?
I don't. What does it mean?
I don't either. I was like, what does that word mean? I just Googled it. So it's a document or record, or it's evidence, such as a document. So title.
Yeah. So you can do that if your ex is being a jerk and won't sign the deed so that you can vest good title. So it's funny because he says, I signed the special warranty deed and I transferred all the debt to my ex.
Psych.
Joke's on you.
Transfer all your rights to that.
Oh no. His name is on the original deed and he never had it removed. Again, I would take, if I were the wife's attorney, I'd say take your divorce decree down, file it with the clerk's office, and you're done.
He signed a special warranty deed. All they have to do is file that.
Oh. But he says my name is still on the original deed as I never had it removed. That
maybe she didn't either. She didn't file it or it's not on there.
Yeah. And even if it was on the original deed, once you sign a subsequent deed transferring your interest, then you have no ownership rights to the house, period.
We won't
Can I
get into
tell-
all the exceptions or arguments to set aside deeds today, though.
No, we're not going to do any of that, please. He did tell us to go down rabbit holes, so here we are. What about, can I be held responsible for future debt concerning the house that my ex may bring? Is he thinking like if she gets like a second mortgage or something?
Maybe, I don't, but the answer would be no, right? I mean, you can't be responsible for any debt that you don't sign to be responsible for. So just don't sign to be responsible for anything.
Right. And then the last thing is, can he be responsible for mortgage debt incurred after the divorce and if I am deceased? I don't know, like, why would you care? You're dead. Don't worry about it. It's just debt. It'll go away.
Yeah, never sued a dead person.
I mean, I guess if she didn't pay it and if they were foreclosing and they had secured a judgment for any debt that was still owed on the mortgage and he left money in an estate, then the mortgage company could secure that judgment through the estate to try to recover it.
Way too complex for our abilities.
It's a rabbit hole. Yeah, don't call us if you're in that situation.
If you're dead, don't call us.
Exactly. So what else? Anything else when it comes to mortgages, refinancing, transferring property? So I guess this is a good one. If there is no provisions with regard to refinancing the home or selling it in the decree, and it's just a wife is awarded the house, period. What does that mean for husband?
It means he's not awarded the house.
And what happens to the debt?
It's in both their names.
Yeah.
Yeah, they're both responsible.
Until when?
Until it's gone.
Yeah. Which is why I say, if you own any property at all, please, please, please hire an attorney, and that way those issues can be addressed. I don't know, like we've never like looked into this. We've never had this issue come up. If there's a subsequent motion that you could file, I don't think that there is.
I don't think it's a division.
Yeah, I don't think there's anything that you can do once that's done. So be careful, my friends.
Cheaper to keep her.
Maybe, yeah. Most of the time that's true. What else? Anything else on this issue? I think we beat it to death. Yeah.
I think we're good.
Okay, awesome. So we tell everybody beginning, we didn't say it in the middle here, but we will say it at the end. If you find yourself in a situation like this, please, 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 please hire an attorney. The reason why we tell you guys to do this is because clearly all of this crap is super complicated. We've kind of given you a general overview on how this stuff works, but I can assure you that when you're in the thick of it, it gets far more complicated than the way that we've attempted to simplify it today. So make sure that if you're going through divorce, if you own a home, you hire an attorney. Do not accept this as legal advice because it is, we don't know your situation, so we can't tell you what to do. What else am I forgetting, Floyd? Am I good?
Follow us.
Follow us. Yes. Wherever we may go, follow us. Have a wonderful weekend. Bye.